Parental rights. Does a state have more than you as a parent? A law paper. I'm just going to read what I wrote here, so if you see me continue to see my eyes go from left to right, it's because I'm reading from a paper that I wrote so that I stay on topic. And I write a law paper, to which I'll provide a link accompanying this video, begins with an early court case concerning a father's rights over his minor son, so as to then investigate the topics of rights of parents over the children versus that of the state. The Reader Digest version of the opening court case is about a son named Edward who returns home from a stint of working at sea and who is still considered a minor. Now his father Joseph, upon his return, claims right to his son Edward's pay. Was he entitled? The court of this time, year 1838, says it's not that cut and dried. The court stated that the father essentially does not have the right over his own pedigree, but rather the state establishes the rights the parent has in the best interests of the child, so that it is through the state, society as a whole, that determines what is the best interest of the child. This law paper that I'll be quoting from a few of its pages is titled Sacred Trust, Sacred Right, and it's by Jeffrey Shulman of the Georgetown University Law Center. And it reads at page 2, referring to the case, it quotes, "For, at bottom, the child does not belong to the parent. The court stressed that Edward, like all children, was endowed with a social nature and was destined for the enjoyment of a social life as a member of what the court called the human family. Edward was invested, endowed by birthright, as it were, with all the rights that belong to other members of this universal family. The court explained, the Creator of man is giving to the child a social nature and endowing him with those qualities which fit him for the enjoyment of social life, has imposed upon the parent, as of the conditions of this being, the obligation of providing for his offspring while they are capable of taking care of themselves. But his children are not of that account born slaves. They do not become the property of the parent. As soon as a child is born, he becomes a member of the human family and is invested with all the rights of humanity." Unquote. This paper is a great read so as to be more clear in understanding the parent's rights, subject to how the state interprets this right as pertains to our own children. Now, before in common law, it was established that the father was the primary owner of the child. Quote here on page 5 from this paper, as formidable a scholar as Martha Feynman has written that, historically, fathers were entitled to possession of their children. In essence, fathers had an absolute right to their children, owning them as if they held a title to them. Unquote. At this time, the state had no right to, let's say, rescue the child if the child was used for slavery or it was being harmed by the father or mother. No means in which to intervene through the common law for a time. And we can also now see of where this can also create an issue in society, whereby society becomes a singular legal personality upon itself. It is an agreement. And so this agreement naturally overreaches each individual's rights, those of parents, because it is in the name of this society that predominantly seeks to be secured. So at this point, we can see in common law for the very beginning, the rights of the fathers over the children were predominant. But as parents became more involved within society and integrated, then the legal personage then overreached those rights in order to protect and secure society as a whole. So how did the state then acquire more rights than the father or mother of the child? We merely have to look to the operation of a trust. The paper quotes, under a trust model of a parent-child relations, biology does not beget rights. It begets responsibilities. It goes on. The trust model is built on the Lockean principle that it is the child who has fundamental right. What William Blackstone called a perfect right is the right to appropriate parental care, including the entitlement to an education that will prepare the child for eventual enfranchisement from parental authority. To Locke, the right of tuition is rather the privilege of children and the duty of parents than any prerogative of parental power, unquote. On page 4, it also states, it is true of our legal past, as it is true today, that claims of the right, natural and civil, were advanced in support of parental power. But, as Hochheimer tells us, the prevailing legal current, driven by equitable force of trust principles, swept away such narrow contentions. End of quote. Under this trust, meaning to completely create a different subject matter, was through the laws of equity and the creation of the trust instrument, which was birthed, according to English law only, from the use to land. As we are coming to learn in this English law series and witness, most definitely, after the Statute of Uses was passed in 1535 by a reluctant parliament against a strong-willed king, that through the need for the law to evolve, according to the interests of the people, that became more demanding in their want to control rights to land. These new rights enjoyed today to land are secured through the advancement of the trust instrument. Joseph Story wrote in 1816, our rights depending upon the mere municipal rules of the state, and may be enlarged, restrained, and limited as the wisdom or policy of the times may dictate. It goes on to say that custodial authority, maintained in the 19th century libertarian treatise writer Christopher Tiedemann, it is not the natural right of the parents. It emanates from the state and is an exercise of police power, unquote. The trust, that which every citizen has accepted today, whereby equity overreaches one's English common law rights, is the type of instrument everyone is currently operating under, so as to next create customary, common, and equity laws for society to be accountable to. Now, as I've mentioned, and most definitely exposed in 1925 through the Land, Property, and Trustee Acts, that all purchases are subject to a trust for sale scheme. Today, that is the case. We are moving into the fourth level of a property trust through these current Zionist operations being nurtured within society they themselves created. It is their creation, as is Parker Brothers creating and trademarking the game Monopoly, which is merely a copycat of today's trust for sale scheme, so as to have the spiritual and legal right to remain in sin in debt under the Christ figure created via the Judeo God. Now, as I've just wrote that and now I've just read it, everything that's happening is under a trust for sale and has been ever since I've been born, and and could be established coherently when we go back to the 1925 Land and Property Acts. Now, by the way, I also wrote this, that is Adam and Eve, are they not technically Jews? Extending this type bloodline, those who later create under this belief of the Hebrew-speaking peoples, this is for the Jews, not for those who are not Jews. And the entire system today is subject to Jewry. The rights evolved from the Sanhedrin and laws of merchants. Now let's look at what was common belief of the people who owned slave ships during the growth of America. Those today who control banking, societal courts, who once held Germany hostage, and before AD 1290 began to get a hold of England's king's interest through debt and usury, and who owns the media and farm industry. What is Dr. Fauci's belief? Is it that of the Zionist Jews? Not speaking of the Orthodox here. The question is, why are we or you continue to support the system under a trust through the guise of Jewry? Is it not your system? Is it not their system? Is it yours? Why are we continually to acknowledge and agree to this system? Now the paper continues on page 4. It says, traditionally, for both legal scholars and jurists, the very word trust was something of a linguistic charm to ward away rights thinking. And just look at those words they use. I mean, they don't mince words here. The law is exact in its delivery. And I'll go on with a quote. For James Kent, the duty to provide for the maintenance and education of the child is a sacred trust. It is the true foundation of parental power, the source of the authority that law has given to parents, unquote. Then also on page 4, it states, why, Story asks, is a parent by law ordinarily entrusted with the care of the children? As a question. His is a simple answer, simply because it is generally supposed that he will best execute the trust reposed in him, for that it is a trust, and all trust that most sacred, no one can well doubt, unquote. The paper is filled with reference so as to investigate further into the parent-child state relationship. And now we have a basic broad stroke of the condition of who we are construed to be as it relates to our lineage and matters of the state. Now I was forwarded in my Facebook messaging, direct messaging, a video of concern orated by the lovely Laura Nina about a man by the name of James Holgate, who is currently being held in a psych home because he broke the conditions of a court order 3 days remaining of a year and almost 2 weeks wait. And he broke the order and able to see and hold his children. I suppose he broke the order because he was in defiance of when he approached the court that he doesn't recognize their authority. Now he basically did not agree with the order and so broke the court's condition with just 3 days remaining. Now I get the frustration of asking this question, who the fuck they think they are, the state namely, to tell me that I can or cannot visit, when I can visit or when I cannot visit my own children. Now as we see here, it is not or has ever truly been his choice, has it? So now James Holgate is being held against his own will in the mental health hospital of Victoria House in the county of Durham, where by now he has captured a ward of the state, and so will undergo whatever the state deems necessary in order to write a formal, professional, recognized assessment concerning his mental health. Now the science of psychology and psychiatric medicine is just more pseudo-science. It acts as another catalyst for Big Pharma, to which many people listening to this also support, because they themselves purchase these drugs so as to assist within assist with their often poor diets and unmitigated stress, as well as receive most often, investment returns through their pension stock portfolios and such that are attached to Big Pharma. This is what I speak about society, all subject to a trust, because we are all in agreement by our actions to support the security of society, that legal personage, then we overreach our natural individual rights. We are doing it, and we are actually funding it because we want, again, returns. We're looking at, we want to pay off our house, we want equity, we want to have a nice retirement, a nice nest egg, and everything we're doing, we are funding the system to which then uses that right to execute matters that are of the heart against us by using the facts and our actions against us. Okay. Now, most all government-related organization of science are pseudo. They are designed to reach the desired objective in controlling sociological issues that they themselves create. Remember that governments of the world use the Hegelian dialectic to regulate the Aristotelian approach to science and health. An Aristotelian approach is just to continue to amass facts upon facts upon facts upon facts, and they just keep on dissecting to continue on with their system instead of going directly to the principle. And they can't go to the principle because the principle will destroy their fiction, their beliefs. And then we all agree to it. Okay? Now, apparently, as Laura Nina relays within her video, that he was considered astute in his ability to navigate the legal system. Although we cannot expect any of us to be experts in all fields of law, when considering the paper I am sharing, that I've just made reference to, this type of study should be predominantly considered when we're dealing with matters of the heart, and the system is otherwise relies mainly on the facts of society that have garnered through society. Now, I wish for the best for James and his family and such, and to which now he's stuck. We know that. And I was once where he is now for challenging the system and my rights, and I can feel James' outrage. Boy, can I feel it. But I would now perhaps at this stage, since he violated an order in the state's jurisdiction, is to inquire what rights he has, and then separate those rights with what he has when he is no longer subject to the trust, no longer subject to the Zionist agenda, no longer subject to jury. Okay, jury is, and the system is what it is. If we go into any instrument, when we go into any store, we are agreeing to a certain level of rules and actions against us. We are agreeing. If it doesn't fit us morally, and it doesn't, by all means, by what we're witnessing today in society, it's not our society. It does nothing for the best interest and the benefit of mankind. It does for the best interest of the system we're agreeing to. So we've got to, the only way that we're going to capture what we already inherently have is to learn what the system is, where it begins and where we end. Okay? Now, after release, and hoping before the term slotted by the court order, that he now can dust himself off and next begin to work towards getting himself out of the system entirely. That is the only way that he's going to work in the best interest of his family. He'll never, or no one watching this, will ever work for the best interest of their family within the system. It is impossible. The system's not designed for your benefit, as we've already discussed. And of course, he will only be ever granted those rights, which we've relayed in this video, is subject to the trust. It's all operating under a trust. Okay? And I'll attach a link to Laura Nina's video, the one that I'm speaking to at this point, and to see if any of you can add any more to it or help James getting out earlier than the time allotted. And we can now all remove the stigma and the stench of the system and regain who we are. And that is not, as I've already mentioned, can never be found within the system, and why I'm doing this law series. So please like and subscribe. I hope to get better at conveying the message. This is all new to me, sitting in front of a camera. But it's a very important message because there is a lot of people leading us astray, and albeit not all of them are leading us astray with intent, a lot of it, they're leading us astray because they themselves have not come to discover what law is, or they'll just say, I'm just going to use the Bible. Well, and they're reading or interpreting the Bible at a Sunday school level, which that's all the system's going to teach you, which all the system's going to teach you with regards to political issues or scientific issues or educational issues. The government is not bound to teach you the principle, is not bound to teach you the law. It has no interest in the privilege of your states and your rights that exist prior to the system. It's not there to teach you that. Ignorance of the law is no excuse to be in violation of it. That's a maxim of law. So they themselves are not to affect the principle for the very fact, the principle that you and I have a right to, directly, immediately subject to natural law, and next is common law, is of no interest to government. They're administrating under a trust for sale, and they're acting accordingly to fulfill their obligations, which I have surmised is a 99-year lease that began in 1925 under a trust for sale scheme, ending in 2024, to which they got to meet those requirements to end that agreement and move into a new trust. So they're moving according to law and according to their agreement, according to all those rules that they have established from that agreement, to which everyone is agreeing to continue to have the pseudoscience of germ theory and to have this Operation Climate Change. None of these things exist in nature. They exist within the system, as do those things that we find ourselves when we're playing a game. We are subject to those rules and that gameplay while we're playing. So whatever comes out, if we have to pick up a card of community chess, then that's what we landed on. Okay? So that's going to continue. It's going to meet its end. So with that, best wishes to James and all those who find themselves caught up in the muck and mire of the English law system and the land and of its right to regulate land and property holding. And to you who are all serving as tenants, as quasi-trustees under the government, to now get acquainted to who you truly are, regain your true power. Start listening to some of the English law series. I mean, you don't even have to do that. You might, get to reading Blackstall's. Don't know where that came from. William Blackstone's commentaries. That man was commissioned during his time to write the law up into that point, so that then law could then in the new systems, in the new colonies that now became Canada and the U.S. and Australia and so forth, to have a basis in which to now situate the courts. Okay? So start learning that. Start reading what law is. Start coming to terms what law is, because when you do, now you're imbibed with the power, because you can see what the principle is and where it ends and where the fiction begins and where the trust starts and where you're confined within the limitations and prohibitions of a trust instrument. Hope you enjoyed the video. As I said, please like and subscribe, share, and best wishes. And to James, and again, I feel your pain, buddy. Best wishes and getting out sooner than later. But again, you can only do best for your family when you fully realize the system that you are inadvertently agreeing to.